Mr. Wood.
Thank you, Your Honors. This case presents the following question. Whether a murder defendant, having killed in a heat of passion, should be precluded as a matter of law from receiving a heat of passion, sudden combat, voluntary manslaughter instruction, simply because the source of the defendant's provocation is at least in part sudden combat with a third party rather than the defendant, than the decedent. This legalistic question gives rise to a more basic question of institutional competence. Who should decide whether a defendant's sudden combat with a third party is a reasonable provocation which warrants reduction of a killing from murder to manslaughter? Should it be juries hearing the totality of the circumstances firsthand on a case-by-case basis, or an appellate court making the decision in the abstract as a matter of public policy? The relevant law here is very straightforward. Voluntary manslaughter is a killing in a sudden transport of passion or heat of blood upon a reasonable provocation and without malice, or upon sudden combat. Instructions on voluntary manslaughter must be given if there is evidence of provocation deemed adequate in law to cause the accused to lose his self-control in the heat of passion, and if the killing followed the provocation before sufficient time had elapsed for the accused's temper to cool. Given that Mr. LeClair stabbed his wife immediately after sudden combat with her brother, Brian Sewell, there can be no question about three things. One, he was in a heat of passion when he killed his wife. Two, this heat of passion caused him to kill his wife.
How many states recognize this third-party provocation?
At this time, I don't know the answer to that question, Your Honor. That there has been a decision in Minnesota that has found third-party provocation to be appropriate, and the drafters of the Model Penal Code have indicated that they think that under their formulation, this would be an appropriate thing to do.
Is this Minnesota case an appellate case?
Yes, it's the Supreme Court of Minnesota, and I've cited the decision in my brief.
And so as far as you know, that's it?
As far as I know, that's it. There is a gathering of authorities by the Model Penal Code not dealing with this specific issue, but there's case law out there recognizing that in general there is a modern trend away from fixed categories of conduct.
Well, let me just ask a question, though. Doesn't Minnesota have a specific statute that's different than our statute?
They do have a statute, Your Honor, and the Commonwealth suggests that, or it may be an amicus, I'm not sure, suggests that that case involved the interpretation of the statute with dictionary definitions of killing by another. Here, of course, as we all know, it's true our statute differs, but our statute is that we have no statute on the substance of the issue.
So the law elsewhere, if Minnesota is clearly distinguishable, is zip.
The law is that's correct, Your Honor. That there is no if you accept that the Minnesota case is distinguishable. I mean, certainly it has no precedential authority on this court. But I think that the Minnesota case is not clearly distinguishable. I think that the Minnesota case is helpful, and I think that it precisely because here we have no statute, this is entirely a matter of common law. This court has the discretion to adopt the appropriate standard here, or to adopt the standard that I request here. And so I think that Minnesota is certainly helpful to the court. I think beyond that, frankly, the Model Penal Code is even more helpful to the court because the Model Penal Code, first of all, it's something that this court has on a number of occasions used as helpful in questions of ambiguity. And I've listed all the places, or at least as many as I could find, where this court has done that in the past. So I think that that's an excellent place for this court to start, a place where this court has a long tradition of going to answer difficult and ambiguous questions. And it's an institution which I think this court clearly has a lot of respect for. Now, because there was a heat of passion killing here, and there was no time for a cooling off period, the only issue is whether this court is willing to recognize that the provocation is adequate in law, as this court has said, to permit the jury to decide whether there is a reasonable doubt whether the events leading up to the stabbing constituted reasonable provocation. And I think that we have to be careful here, and this is a point that I did not adequately, I think, brief, and it was very helpful to me to have the amicus brief of the Committee for Public Counsel Services, which I would urge the Court to take a look at here, because there is this notion that the provocation has to be objectively reasonable. And I think that that's an unfortunate phrase because it's a little bit misleading in this particular context. Professor LeFave, in his substantive criminal law treatise, has, I think, explained this issue better than anyone else, and the Committee for Public Counsel cites it in their amicus brief. Professor LeFave writes, "What is really meant by reasonable provocation is provocation which causes a reasonable man to lose his normal self-control. And although a reasonable man who has thus lost control over himself would not kill, yet his homicidal reaction to the provocation is understandable." In other words, what Professor LeFave is saying is that the voluntary manslaughter killing is unreasonable. All voluntary manslaughter killings are unreasonable. And yet, the ones that we recognize as voluntary manslaughter are, in our view, understandable.
Well, I think what the point that LeFave, as I understood, was trying to make was that you don't look to blameworthiness. I mean, in other words, by anchoring it in, the provocation has to come from the victim, somehow suggests that you've got the two ultimate you've got the two ultimate actors, and as the victim somehow contributing, and it's almost a sort of contribution thing. And what LeFave is saying, no, get all of that out of the way. Just look to see, in essence, what his state of mind was at the time, and was there adequate provocation for him to have done this particular act. Correct?
Yes, I think that that's I think that's absolutely the way I would ask this Court to look at it.
But couldn't we draw, and it seems to be most of the other states have drawn the same policy line that says, particularly looking at sudden combat, we understand, use your term, we understand that a person can become enraged and desire to lash out at the person he's fighting with. And we may even put the word reasonable on that. You know, a reasonable person would get sufficiently angry at the person that they're fighting with to get carried away and do something that they shouldn't do. But we are not prepared to say that just that general state of being upset because person A is fighting with you now makes it even understandable that you can now go lash out at whoever else happens to be around. And that seems to be what you are now asking for, that once you get into this state, that you now, you can commit crimes against other people and still have the benefit of the reduced charge of manslaughter. That does seem to me to be a policy issue that is appropriate for the courts or for the legislature in a statute, as they apparently did in Minnesota, to talk about. Why is that a jury issue? That's a policy issue, it seems to me.
I think Your Honor has put your finger on the crux of this issue. But I disagree strongly, politely, with the last part of what you said here. And that is that, or the characterization that what I'm asking for is the permission for a jury to decide. First of all, I'm talking about a jury being allowed to decide. I'm not saying he should be convicted of voluntary manslaughter. I'm saying, first of all, should a jury be permitted to make the decision, whether there's a reasonable doubt here. But I'm not asking for a rule that permits a defendant to, or the instruction to be given any time a defendant lashes out at anybody who happens to be around, which is how Your Honor put it. I'm suggesting that this is not that situation. That situation has been dealt with before, and I think that that was the Robinson case, where the elderly man got into a fight with his wife, and then he drove to his nephew's house, and then his nephew took him to the hospital, and then he pulled out a knife and started stabbing people. And I submit that this case is clearly distinguishable from that case. And I submit that that is, first of all, a cooling-off case, and there's also a causal connection situation there. Here, we don't have a stranger. He didn't attack a stranger. He attacked a very specific person, and I think that's crucial. He attacked his wife. Now, I recognize Your Honor's trouble with this, and I think it's the center of the case, of course, the commonsensical trouble. His wife didn't start the fight. It's a little ambiguous who started the fight, but at the very least, she wasn't participating in the fight. She was just standing there. And in fact, she was calling the police.
And telling her brother to let him go.
Yes, yes. Absolutely.
I mean, in other words, what I say is, however reasonable or understandable it might have been for Mr. LeClair to be angry at Mr. Sewell and to be lashing out at Mr. Sewell, that he can't then just sort of take that, well, now I am in an enraged state because of what Mr. Sewell has done. I can now, as it were, take it out on anybody I please because I'm still in that state. You're saying once you're in that state of mind, that's your state of mind, and it doesn't matter who your victim is as long as you're still in that state of mind. I think that's a rather significant leap from what our jurisprudence has been, and a leap that has grave policy implications.
Okay, and I clearly am not quite doing my job because, again, I'm going to try and say it again, that I'm not saying that he can, well, first, he cannot go and just kill or stab or attack anyone. I'm suggesting that in this, the jury should be given an opportunity to decide this particular situation. In this particular situation, the target of his rage was his wife. Now, I submit that you've got a situation here where the issue, as Professor Lefebvre has put it, is not whether Mr. LeClair's act was reasonable. Of course it wasn't reasonable. All involuntary manslaughters are unreasonable. The issue is rather whether it is possible that a reasonable person facing the same circumstances could have been sufficiently provoked to lose his self-control and commit this particular unreasonable act, this particular act of attacking this particular person, not just any person who happened to be around, but his wife in this particular factual situation.
Well, what provoked him to kill his wife?
Well, I think that you have to look at the totality of the circumstances here.
But what circumstances provoked him to kill his wife?
Well, I've listed the totality of circumstances. I made the case. I submit you have to look at the totality of circumstances. I said that in my brief. It's at pages 47 to 49.
Let me simplify it. I suppose it could be something like this. I'm not saying this is the facts in this case, but it could be something like this. I'm involved in a unbelievably heated fight with brother. Brother says to wife, go and call the police. I am so angry that brother has told wife to go and call police that I turn to stop wife calling police and in the course of doing that stab her to death. Right?
It's actually, I submit, that's part of it, and that's the core of it. There is a long history here, which is laid out in the record, and I marshal the facts. The facts begin a month before this, where he is trying, first of all, he's battling a long-standing history of depression. Bear with me here. I know I'm not raising irrelevant points. He is trying, at the beginning of December, this happens on January 4th, the beginning of December, he begins trying to wean himself off of Paxil, an antidepressant, at his wife's request, because it has sexual side effects. And she says, I'm going to leave you if you don't get off the Paxil. So he's trying to get off the Paxil. He's done this once before, where when he did that, he experienced heightened irritation and became more confrontational.
But why didn't he kill his brother-in-law for telling his wife to go call the police?
Your Honor, first of all, the human heart is a mysterious thing. I don't think that we're going to be able, it is an unreasonable act. I'm not suggesting it's not an unreasonable act. What I think Your Honor is looking for, understandably, is a rational explanation for why you would do this, a defensible, perhaps, explanation. And I submit that in these sorts of situations where you're talking about heat of passion killing, which this clearly was, and I submit if you listen to the 911 tape, you will see beyond any dispute when his voice is recorded.
Let me put it to you this way. Supposing this scenario took place just as it had, but you add a third person. There's a third person or fourth person who's in the other room with the telephone on a long extension cord, and the person comes in with the telephone. Could he kill this person who just happened to walk in with the telephone to accommodate the wife, to make the call to the police, and thereby use that and raise this defense that you're talking about?
To answer that question, I think I need to go back and perhaps take some partial issue with Chief Justice Marshall's characterization that perhaps he was killing her because of the calling the phone. Calling to the police, because calling the police, I think that suggests some sort of intent to stop her from calling the police that isn't really accurate here. It's more that he's enraged at her because she's the cause of this entire situation. she is leaving him. She left him on Christmas Day, actually, left him and the children on Christmas Day, and he's enraged at her. She brings her brother over, and today, finally, is the ultimate confrontation. She says, that's it, I'm leaving you, I'm getting a restraining order, I'm sick of this, I'm out of here. And I brought my brother here because I'm scared of you. The brothers, he goes outside, and the brother's pointing fingers at him, they're barking back and forth, and then he and the brother get into a conflict and fight. I think, the closest you can come to a rational explanation is he sees her as the cause of all of this, and he's beaten in front of his own children, put down on the ground. He's bitten by his own dogs. His children are screaming, upset. And he pops up, and his rage is at his wife because she's the cause of all of this. Now, your question, if there's another person here, and this person walks in and has no relation to this nuclear family situation, I would say, no, in that situation, the instruction would not be appropriate. I think that you always have to look carefully at the totality of the circumstances to be very careful to understand how this third party relates to all of this. But no, I don't think it's what this...
Part of the problem is, all this history you've laid out, as you would readily recognize, if the brother hadn't been there, none of that would have amounted even close to adequate provocation in law.
I think that's fair.
You're relying on, but there was this physical confrontation with the brother that to become your avenue to open up a defense that otherwise wouldn't exist.
Well, I think that's sort of like saying, a bar fight without the bar fight doesn't create a case. It's not at all controversial to say to this court that sudden combat is a basis for a heat of passion defense. And here, if you look at the 911 tape, it's clear that a heat of passion had been created. It's blood curdling, but you hear this 911 tape, him screaming at his wife as he's stabbing her, you wanted it this way, you wanted it this way, you wanted it this way. He's completely off the deep end. And I submit that it's clear that what triggered that was the fight with her brother, and that this is a very understandable human reaction. It's on his own property. But the case law from this court recognizes this, that sudden combat is a traditional basis for a heat of passion defense. And that's what happened here. We can't change the fact that there was sudden combat.
Right, but we have always done that in the context where the heat of passion is directed at the person you're fighting with. We have not expanded to, you get into a heat of passion because of a fight, and now because of some larger context to who else is there and what you think of them in addition, that now opens up a manslaughter defense if you, in that heat of passion, lash out at one of them instead of the person you're fighting with. He didn't get up and stab the brother.
I think that, again, we need to I want to spend some time on the institutional competence issue here. What I'm asking you to do is not, of course, to find as a finding that he's guilty of voluntary manslaughter. What I'm asking for is that a jury be permitted to answer this question. And I think that this conversation is taking place against this backdrop. And if the court denies my request, it's essentially saying we don't trust juries to answer this question. The reality is this man killed this woman in a heat of passion. Now, we can say that it doesn't make sense to us that he didn't kill the guy he was fighting with, but instead killed his sister, the woman he was married to, who in his mind perhaps caused all of this. He shouldn't have done that. As a matter of basic fairness, he shouldn't have done that. He should have attacked the guy he was fighting with. But the reality is, that's what happened. That's what was going on in his mind, and he killed her in a heat of passion caused by this sudden combat, and there was no time for cooling off. So I think we have to, as a matter of fundamental fairness, think about letting a jury decide whether, from their point of view, there's a reasonable doubt that because of his human frailty, he did this as a result of this heat of passion, and whether this was understandable. Whether from a jury's point of view, there's a reasonable doubt whether this was understandable. Because, again, we're talking about would a reasonable person pushed to this extent do this? And I think that that's a factual question. It must be a factual question. And that's, as a factual question, a question that is most appropriate for a jury to decide. Every case is different. We're talking about the totality of the circumstances. And this court, if it denies this request, is essentially saying that there can be no set of circumstances in which a defendant can be attacked by a third party and then kill another person and have and that resulting in an understandable heat of passion. And I submit that that is institutionally not a sensible solution here, that juries are the better bodies to deal with this question on a case-by-case basis, considering the totality of the facts, looking at the parties, hearing the evidence, and determining the credibility of that evidence. Here, of course, as an appellate court, you would be making a much broader policy determination. And I submit that while perhaps in the vast majority of cases a third-party provocateur would not warrant a voluntary manslaughter, I submit that we shouldn't make a blanket policy statement that it never can be the case that a third-party provocateur can warrant a voluntary manslaughter instruction. And we should leave that question and that difficult emotional issue with the jury to decide, not with an appellate court that has not seen the specific facts of any given case.
Thank you, Mr. Wood.
Thank you.
Mr. Waterfall.
May it please the Court, I'm David Waterfall, Assistant District Attorney for the Middle District.
Mr. Waterfall, why doesn't Mr. Wood's argument make logical sense?
Logical sense, Your Honor. First of all, in addition to being unjust, it is illogical because someone who is reasonably provoked by another person to the extent that they would actually want to kill, they reasonably attack the person who has acted towards them. They don't kill an innocent bystander by definition.
They may, but it strikes me that this is that circumstance where the person could reasonably have blamed his wife for creating this horror show. What
he might have blamed
was this incredibly passionate horror show.
And he might have blamed her for some things, Your Honor, but we're talking about sufficient provocation here.
Mr. Waterfall, can I ask the question this way, which I find it was really Mr. Wood's last formulation, and I'm not suggesting he should have made it first, but which is at the moment we have a rule that says in no ever circumstance does one ever have the opportunity for the jury to decide if the sudden combat, which gives rise to the heat of passion, is engaged in with a third party. The question then arises is, does that make sense? Not whether in every circumstance, and I assume that implicit in Mr. Wood's request that a jury be permitted in some circumstances is that a trial judge would be permitted to view the evidence as to whether this was an appropriate case. And I'm trying to think of other circumstances, for example. I think, for example, of a sudden combat, a melee, he lashes out, he stabs a person who didn't initiate the sudden combat, who happened to have stepped into the way. Would we say no opportunity for the jury to consider this because whatever theory you want to do?
We still would, Your Honor, for a variety of reasons.
So you're saying never,
Never.
ever, ever.
It's a policy decision. This Court said less than a year ago that it's, quote, a basic truth, unquote, that the provocation must come from the deceased victim. That was less than a year ago. Nothing has changed. It's still a basic truth. And that basic truth has been derived from a long line of precedent, starting Commonwealth versus Webster all the way through Commonwealth versus Gruning, Robinson, up to Ruiz. And there's no reason to change the Massachusetts law.
I understand that. What concerned me when you actually look at those cases is that often they are cases that if one were to take what I think Mr. Woods has sort of narrowed down, they would say they fall outside of that. So, of course, one repeats well-established law until you're confronted with a case which says, does this make sense in this? Yes,
and I understand the case you're saying that you mentioned before where someone lashes out, and there are a few things that we'd have to consider here. Is one, that's not the case here where the defendant lashed out and accidentally killed the wife. He intentionally killed the wife and not the brother. We have to keep in mind that justice takes precedence here, and the person who was killed is an innocent victim. And this Court has never partially justified or excused the intentional killing of an innocent bystander who has nothing to do with the provocation. By definition, the innocent bystander has nothing to do with the provocation. And
it seems to me that and maybe this is a valid way to look at it, that goes to essentially what LeClair is saying and the Model Penal Code is saying shouldn't be the consideration, namely the blameworthiness in some kind of way of the victim. And I have to say that I find that a rather uncomfortable place to be, because in my judgment, even if you provoke a fight, it shouldn't be that you therefore, that your killing is any less, worse than somebody else's killing. I mean,
I agree, Your Honor. And this third-party provocation or transferred provocation, or however you want to call it, it's unjust because the mitigation that has always gone along with manslaughter has always been based in part on taking into consideration the actions or the conduct of the victim. And Massachusetts has always required a causal connection between the killing and the provocation. Now, where the defendant kills an innocent bystander who has nothing to do with the provocation, there just isn't a causal connection that you can pinpoint.
Well, let me just see where this is going. If instead of her brother it was a police officer and came in and tried to calm things down and was talking to him, and all of a sudden the defendant becomes increasingly enraged. The police officer goes to put handcuffs on him. He breaks away from the police officer and goes and stabs his wife. Is the result the same in your view?
I would say it would be the same, Your Honor, because in that case that you've just stated, again, the wife did nothing to provoke the defendant. Taking out one's frustration.
Let's just take you. And again, I think it's a very interesting case. In that case, you said the wife did nothing to provoke. The point of Mr. Chauncey's argument, as I understood it, which is why he dismissed my hypothetical very clearly, is the wife is in fact the provoker, not in a blameworthy sense, but the provocation for what is happening is the wife's actions. That the fight with the brother increased his passion so that it really became a heat of passion was provoked by the wife saying, I brought my brother to take me. The brother tries to restrain him. I don't know all the details. And so Mr. Wood is saying, look at where the provocation was coming from. Not look at where the provocation was coming from to blame the victim, but look at where the provocation was coming from, so that if we look at provocation as objective, it's an objective. I mean, you ask the jury objectively to decide. That's what I understood Mr. Wood to be saying.
And I would point to Justice Osman's concern that had the fight never occurred, it seems that the defendant would never have killed the victim in this case. And
no, well, we don't know that. I think what Justice Sussman was saying
if the
is
fight
that
had never occurred, there wouldn't be any basis for a manslaughter instruction.
Correct.
And
True.
Mr. Wood acknowledged that.
yes, and also if we're looking at what the wife actually did in this case, she left him. She told him that she was leaving, that she was going to get a restraining order. It's already been stated before when my brother was speaking that the actions of the victim here didn't even come close to anything resembling sufficient provocation.
That seems to me to be not for saying that you shouldn't have third party, that it has to be the victim provoking, but that recognizing that the provocation might have come from the wife, accepting Mr. Chauncey's argument, the provocation coming from the wife was not adequate to support this kind of, not that that something happened in between.
Understand. Yeah, and I would say again.
Put it this way: you could have a situation, not this case, with the wife standing with the brother saying, "Go for him, beat him, beat him, beat him, go for him. I've taken so many beatings from him. I just love him." Different case.
Well, if that were the case, if you're saying that, if you envisioned a case where the wife or the other person was basically participating in the
Well, not
provocation.
participating.
A
but-
joint venturer, so to speak.
Yeah.
Well,
Basically,
even that-
Encouraging, aiding, and abetting.
Basically, but a third party provocation rule would encompass situations where we have a purely innocent bystander. And I would say in this case, we again do have an innocent
This
bystander.
seems to me, Mr. Wood's argument reduced to its basic term seems to me to be another variation of blame the victim.
I agree, Your Honor. And to really understand, I think, this third-party
I mean,
provocation
how would you
rule-
even explain it to the jury? That they were, he was provoked by the brother?
Exactly, Your Honor.
And who got the brother there? Well, on the evidence, the wife got him there, which was perfectly permissible because she
Right.
expected some kind of difficulty with this man.
Right.
And the jury's saying, well, my gosh.
Right, and if we look at this in the context of justice, I would suggest that taking out one's frustrations on an innocent victim, someone who didn't provoke you, should aggravate rather than mitigate the defendant's guilt.
Where would you draw the line on this? I mean, suppose the guy
Exactly,
comes
Your Honor.
home drunk and he says, I had a big fight down in the bar room because of you. To the
Precisely.
wife, because you told me, yesterday that you're going to leave me and so on.
Exactly, and I think we brought up I believe it was Justice Sussman brought up a fact pattern where someone is provoked, say for example, I leave the courthouse and I'm attacked on the street by some sort of criminal. I could take out a gun and kill anyone on the street, any innocent bystander, and I would be entitled to a voluntary manslaughter instruction. I'm not saying that's what happened here, but under a third-party provocation, that would have...
We may disagree with Mr. Wood's theory, but I think we have to stick to Mr. Wood's theory. The more, from a conceptual point of view, the question is, do you never in any circumstances, and then once you get over that, the next thing is, are these the circumstances where, had the judge allowed it, it would have been appropriate?
Right, and again, I would say it's a policy decision because we have this objective, reasonable person standard to decide what is sufficient provocation. And it's plainly unreasonable always for someone to kill an innocent bystander. We have to see where this rule comes from. It's borrowed from the Model Penal Code, and it flows from the Model Penal Code, this third-party provocation rule or interpretation, because the Model Penal Code defines manslaughter in a very different way than we do under our common law. And the Model Penal Code acknowledges this. It's an expansive view. A note to the Model Penal Code acknowledges that it involves a major reconstructing of the common law. And under the Model Penal Code, they use a purely subjective standard to determine whether the provocation was reasonable. Now, if we use a purely subjective standard, one can see where the third-party provocation comes from, because we're just worried about what's going on in the defendant's head. How does he see things? But that takes away the causal connection requirement and the requirement that the defendant's actions must be objectively reasonable, which is what we are required to go by under Massachusetts law. So because the Model Penal Code is just so different in general, and its treatment of homicide, manslaughter in particular, it really has its interpretations, for example, this third-party provocation rule, that really has no bearing on how this court should interpret its own Massachusetts common law. In fact, in two cases, most recently in Commonwealth v. Rivera in 2004, this court rejected a request to adopt the Model Penal Code's view on subjective provocation. And the court said basically that the Model Penal Code isn't the law of Massachusetts, our common law is, and that if you want to change our homicide common law, you should go to the legislature.
Well, wait a minute. The way common law is developed is by judges. So you don't have to go to the legislature. We have changed the common law, and we do it frequently. That's a judge-made.
That's true, Your Honor. But this court has also stated on several occasions that with regards to the homicide common law, it's very reluctant to make any changes. And
that may be true, but I just was questioning whether you have to go to the legislature. We don't have to go to the legislature.
But I would suggest that the defendant is in the wrong forum, that this court has stated that with regards to a change in the homicide common law, it's stated that any recodification, however desirable in the homicide common law, that this court, the court has basically stated that the defendant should go to the legislature, because the legislature is primarily who defines and creates criminal law in our state. So I'd basically like to also just state that because we have this reasonable reasonable objective standard in determining what provocation is in our state, it's incompatible with this third-party provocation rule, because it is basically something that flows from a definition of manslaughter that is foreign to our definition, and that it is objectively unreasonable, per se, to kill an innocent bystander, someone who has not provoked you. And that's what we have in this case, and that's why the defendant wasn't entitled to a voluntary manslaughter instruction. If the Court has no further questions?
Thank you.
The rest of my brief, thank you.
Thank you, Your Honors.